And what's important to know about ICE detainer requests is the vast majority of immigration violations are civil. They're not criminal. They're civil. There are a few immigration violations that are criminal, and they typically, if ICE comes to you and asks to detain someone, it will be a court order. The vast majority of ICE detainer requests, and where counties are getting in serious trouble, is an ICE detainer request is a voluntary request for the county to hold somebody in your jail up to 48 hours after they would otherwise be released by the courts. So when an ICE agent shows up and gives you a detainer request, ICE holds no liability. It is not an order of the court signed by a judge or a clerk, and it is a voluntary request. So we have had counties that have said, well, we'll honor the detainer request, and then the ACLU shows up and starts suing you. And if you're in Suffolk County, New York, you're now paying out $60 million in damages for honoring these, basically the equivalent of an affidavit. So that's where we're saying to our members, look, it's up to you if you want to partner with ICE on 287G or any other part of the detention side, but just understand your liabilities. You can tell ICE when you're going to release people and not be in trouble, but if you're holding people past the time when the court would otherwise release them, you better watch out, unless you have a state law that provides some immunity for the county. So that's where your insurance companies, your insurance pools, and you as commissioners got to watch out on the liability. And so that's our job as intergovernmental partners, is to get beyond the media, get beyond the noise, get beyond the partisan rhetoric, and get into the practical reality of these issues and what counties as institutions have to deal with.